the relevant law and procedure relating to bail applications in Hong Kong. For this session, you will need the following documents: Course Training Manual 2, pages 16 to 26, pages 56 to 65, Course Training Manual 3, which is the record of bail proceedings, page 9. Essentially, why we are providing this little session is traditionally students ask for a refresher on the relevant procedure and law with respect to the bail applications that they will be conducting for the CPS sessions, the court practice sessions. So let's start. Practitioner's approach. The procedure that I'm going to outline at the outset relate to non-NSL cases. So effectively, all cases start in the magistrate's court. So all criminal proceedings start in the magistrate's court. The more serious ones, of course, will be transferred to the district court or committed to the court of first instance. But they all start at the magistrate's court, including murder and treason. With respect to bail, the magistrates have the power to grant bail in all cases except for murder and treason. In reality, it doesn't require any law to state this, but it's more logic. The more serious the offense, the less likely bail will be granted. Serious offenses such as trafficking in dangerous drugs, robbery, rape, or cases involving sexual assault of minors, the chances of securing bail are slim. But I would persuade you not to consider that as a block to either applying or to considering making your bail application, because magistrates are open to being persuaded by conditions that you offer or propose that show them that they are so onerous that it's very likely that your lay client, the client, defendant, the accused, will appear at the next hearing. And because there is no black and white with respect to non-NSL cases, you do have the freedom to explore and discuss with the prosecution what their objections are and to offer conditions to allay their fears so that they modify their objections based on conditions. Let me show you a few examples later on in this recording. But just for your reference, if bail is refused, of course, there is a review, and there's also the right to apply to the court of first instance under Section 9J of the CPO, excuse me. So let us imagine you are solicitor advocates, all of you, for the purposes of discussing the first steps for securing instructions for a bail application. Generally, solicitor advocates or solicitors will attend the police station or the ICAC offices to handle any initial inquiries with the police and persuading them to grant police bail. Solicitor advocates may receive instructions from the accused directly or from relatives or indeed the employer, but of course all of this needs the consent of the accused. So in practice, if there's going to be a contested bail application, in other words, that the police or the ICAC, through the prosecution, raise objections to bail, what generally happens with seasoned solicitors is that they contact the OC case. OC case stands for officer in charge of the case, either the police or the ICAC, and they have a discussion. Generally, they call it sweet talking. Alternatively, it's really simply asking them, please tell us in simple terms how complex this case is, how serious is the evidence that has been secured by the police, and what are your objections? Normally, you can discuss with them if they say, well, we're very concerned because there's a young child involved. You say, well, if we undertake not to interfere directly or indirectly with the witness, if we undertake not to go to a certain location, or we undertake not to visit this area or go within 500 meters or 1,000 meters of this location, would that be amenable to the prosecution? And so sometimes a lot of the negotiations happen before the actual hearing in court. And that's something that I would like you to be aware of. We won't necessarily have the chance to practice that negotiation on this course, but I want you to be aware that this is what happens in reality. To help you prepare gathering your information for the bail application, we have a bail checklist. In the next recording, we will go through the checklist step by step. This is actually a document that is used by most practitioners. I know for a fact because my chambers uses it. I received it from my former pupil master, the late Mr. Sandy King, SC. So the documents that we provide to you on the program are used, we call them practitioner's checklists, because this is what we use in practice. There's no draft version, there's no academic version. It is a practitioner's checklist. So when we go through that checklist, we will show you how to record all the relevant information in order to make a bail application. There are also a list of other issues where you may not have the information at hand, but they will serve as a reminder that you need to obtain that information at a later stage. They will also lead you to a chain of inquiry. They will also highlight the gaps in the information that you have, and to be wary, because where there are gaps, there is missing information. So you have to be careful about what you put forward to court unless you are sure of the information. what is important to stress is that a bail application is not the avenue or venue for a detailed discussion or analysis of the strengths or the weaknesses of the prosecution case. There are several reasons for this. Number one, you do not have sufficient instructions at this stage. Number two, you do not have the prosecution papers or indeed the evidence in the case. And number three, your client may not be in a position to provide you with full instructions. So bail application has to be limited to answering the questions that the court needs to hear in order to consider whether or not to grant bail. So let us now pause, because what I'd like to do is discuss a few examples of the possible objections that the prosecution may raise and possible conditions that you may offer to persuade the court. But the best way to do that is to look at a document that the court uses. So this is the extract of record of bail proceedings, and you will see that there are 4 copies. You only have 1. This is the actual document provided to us from the court. I'm now going to bring that up on the screen and take you through it step by step so you understand from the magistrate's point of view what it is that you need to complete in order to consider bail. As you can see here, this is the extract of record of bail proceedings, which is in your volume 3 of your course training manual. Of course, name, case number, all self-explanatory. And you will see the first column, granted bail, the first box. Now that granted bail, I have to say, for your practice sessions, you won't have bail granted instantly. You have to argue your position or argue on behalf of your client. So let's have a look at bail refused, remanded in police custody, or bail refused, remanded in jail custody. Well, what is the difference between police custody and jail custody? Very simply, most defendants, I would say, do not want to be remanded in police custody. Number one, the facilities are very poor. There's no shower facilities. There are no access to visitors. And also, if there is any issue of complaint against the police or harassment, or indeed they're going to challenge any confession and it's not made voluntarily, your client will not want to be remanded in police custody because there is a risk they may possibly be harassed. So generally, remanded in jail custody is where it's run by the correctional services. Visitors are permitted, they can bring in the supplies, for example, toothbrush, toothpaste, or they can purchase them. Their snacks, they can have shower facilities. So generally, they tend to opt for jail custody. Now, if you look further down, the court will say, well, bail has been refused because there are substantial grounds for believing that the accused would. Now, A, B, C, D, and E are the factors that the court will take into account, that they fail to surrender to custody as the court may appoint. Probably because the prosecution has stated they either have a history of absconding, or they were found at a location with an attempt to abscond, probably the airport, or indeed the border. They may commit an offense while on bail. It says here the correct phrase is whilst. This is something that has been an anomaly and it's always been there, but they are likely to commit an offense whilst on bail. They may interfere indirectly with a witness. This should appear to you when there are cases of domestic violence. There are cases involving a relationship between employer-employee, or indeed any other type of relationship where there is a likelihood that they have friends who they can contact to interfere with them. So you should already be aware what the possible objections are: pervert or obstruct the course of justice, and others. So I'd like you to imagine now that you are defense counsel and the prosecution has raised the fact that they're likely to abscond. Now, sometimes there could be a very simple explanation in order to counter that. We had a case once where the prosecution said the reason they're objecting to bail is because he was arrested at the airport. Now, those facts can be raised to the court. You check with your client. And when we did, we found out, yes, he was at the airport, but he was at the arrivals hall waiting for his relatives to return because they had a lot of luggage and he was going to drive them home. It was a very simple, innocuous explanation. So when the prosecution had told the magistrate, well, he was arrested at the airport and therefore there's a chance that he may abscond, we then counted, yes, it was at the airport, but it was at the arrivals lounge. He was not departing. He did not have a ticket. He was not at the check-in counter. And when that factor was raised and clarified with the court, they then realized, well, this person is not going to be a substantial risk, and we could offer other conditions to persuade the court. With respect to commit an offense whilst on bail, generally the prosecution will not raise it unless there's a history of it. So if there's a history, or the defendant has actually allegedly committed this offense whilst on bail for another one, then of course the chances of securing bail are very slim. There are very unusual circumstances where the court may consider it. If it's a very minor offense, then they're likely to grant bail, but other cases they won't. Interfere with a witness. Those are the type of cases where there's a triad element, or where there is, as I mentioned earlier, a relationship or involving a minor. Others could be breach of a probation order, breach of community service order, or indeed they had a hospital order imposed, but they had left the hospital. So these are other factors that the court can consider. Let's turn to the reasons in support of the refusal to grant bail. Here again, you've got the reasons, the nature and seriousness of the alleged offence, including likely disposal in the event of a conviction. What that means basically is that it's very serious and they're likely to face a very lengthy term of imprisonment. And therefore, the chances of them of absconding are high. In other words, to avoid a long term of imprisonment, they will escape. What you can do to counter something along those lines are, generally, most people in Hong Kong would probably have very close ties. So you mentioned the close ties, you mentioned their home. If they own their property, it's very unlikely that they would leave. You could also offer a surety. A surety generally is quite persuasive, depending on the amount and, of course, the nature of the relationship. An employer is very persuasive, or a elderly family relative. Surrendering travel documents. That is, surrendering travel documents is a very compelling condition that can be offered to the court to persuade them that the person will appear at the next hearing. If they have a previous record for absconding other proceedings, that is not necessarily another block to applying. I say that because I really want you to consider applying your powers of persuasion. Examine it. What happened in the last proceedings? Was it over 15 years ago or 20 years ago when the person was a juvenile? Was it a very simple mistake? Did they just get the date wrong? Or were they in hospital? We have had cases where a warrant has been issued for the arrest of our client because they didn't appear at court, and it later transpired that they'd had an accident on their way to court and was taken by ambulance to the hospital. And in that case, the court accepted the explanation once it was verified and did not escheat bail. Escheat bail means to forfeit their bail, and then simply adjourned the matter till they were able to appear in person at the next hearing. If we continue looking down the list, lack of local ties, it's difficult to suddenly come up with local ties, but what you can do is offer a more substantial sum for cash bail, and indeed the surety. They appear to have no fixed abode. Sometimes there are homeless people and it's difficult for them to be tracked, and that may be the reason that the court may use not to grant bail. Alleged to commit an offence or these offences whilst on bail for other matters. That's happened with respect to my previous cases where they are unfortunately drug dependents, and so they have committed offences, either theft in order to secure money to purchase drugs, or they have been arrested with possession of dangerous drugs. These cases require more of a rehabilitative approach, and that's what we consider in mitigation. But in these particular cases, the court feels, or they take the view that they're likely to continue to commit offence whilst on bail. That is a breach of our bail condition, and therefore they're unlikely to secure bail in this particular case. Criminal record of similar offences. Again, criminal record, don't see that as a bar to bail, because sometimes people have criminal records that date back to 15, 20, 30 years. You have to look to see whether or not they are recent, whether they are relevant, and what indeed was the penalty in that particular case. Other suspects at large. This generally occurs when there are gang cases or tribe-related cases, or if they're drug-related cases. And so there is a risk that if your client is released, they may alert them, they may help dispose of certain exhibits or evidence. And that also leads us to the next one, stolen goods exhibits still to be recovered. Let's move on to bail conditions. They're fairly straightforward. Cash bail. Cash bail, I would like to raise with you this very interesting example. Actually, no, I will show you the recording and then I'll ask you your opinion on it. So this cash bail, this surety. Own recognizance is still on this chart. Please delete it. There is no own recognizance in Hong Kong. It is either you have to offer cash or a surety who can offer cash. The surety can offer own recognizance, but not you. Now, a surety is basically like a guarantor. And I would ask you to very carefully read the section, because there is a warning with respect to indemnifying a surety. What does that mean? Basically, in simple terms, listen, will you be my surety? Will you be my guarantor? And I'll either pay the sum for you if required, or I will compensate you in some way. Now, a surety does not have to offer the sum, or when I mean offer, they do not have to pay it immediately. However, if the defendant or the client doesn't appear at the hearing, the surety will be questioned by the magistrate, and depending on their explanation, they may have the amount forfeited. So they don't have to hand it up at the outset. It's just there as a guarantee. Right? Other conditions: not to leave Hong Kong. That also means completely not to leave Hong Kong. There are many, many clients who have appeared at the border heading to Macau, and they have been arrested because they're trying to attempt to leave Hong Kong. Macau is not part of Hong Kong, and so you need to make that clear to your client. Surrender all travel documents prior to or within 2 hours or 4 hours of the release of custody. What about ID cards? Do they have to surrender ID cards because you can travel with your ID card? The answer is no, because under the law, you are required to keep your ID card on your person. To reside at the address given. So that may be several situations. If, for example, it's a domestic violence or a domestic assault charge, then one party, normally the defendant, will undertake to reside at a different location, and that address will be provided to the court privately through the clerk, not read out in open court. If the court accepts that, then they will indicate that the person should reside at the address that's given. Other scenarios may be when there is a juvenile or a young person. For their protection, they may be required to reside at the address given. It may even be a protective home. To obey curfew, curfews are normally imposed for young offenders, and generally it's from, say, 8 p.m. or 9 p.m. till 7 a.m. in the morning, but the time is flexible. Then they can report to police stations between these hours. These hours you suggest, and the location of the police station is suggested by council, depending on their work or depending on where they live. Any change of residence you have to notify within 24 hours. So this basically is the form that the magistrate, not basically, but is the form that the magistrate has to complete. So in order for you to be an effective advocate, I will first promote you and make you a magistrate when we watch the first recording. And you need to complete this form and consider whether or not you're going to grant bail. If you are, what conditions you will impose. Students, what I would like to do now is to raise one point with respect to where your client tells you they've been subjected to assaults, threat, inducements, for example, at the hands of the police at the time of the arrest or whilst in police custody. So there's something called CAPO, it's the complaints against the police. There are two ways of dealing with this. What I would advise you to do, depending on your instructions, is you will not have at the stage of the bail application sufficient evidence, information to support any complaint. You cannot therefore give a detailed complaint to the court and say PC 5555 kicked him on the left thigh and then punched him in the right ear. This was followed by PC 333, who grabbed his phone with his right hand and crushed it with his foot, and it is therefore no longer usable. He could not use the information. The reason you don't do that is threefold. Number one, you cannot verify anything at this stage. There's not enough information. You cannot take the risk of providing. Number two, in the event that your client is remanded in police custody and it has been known in court that this complaint has been made, they will be anxious. They may be anxious that there may be repercussions. Number three, what you have to do though is to make a note on the record. And how do you do it? Let me demonstrate. And I will include this demonstration again just before you prepare your bail application so it's fresh in your mind. You will say, Your Worship, there is one final matter that I wish to raise, and that is that we wish to note for the court record that there will be a complaint against the police. You can either say there'll be a complaint against the police or a complaint will be lodged with CAPO. The courts do not ask for detailed information at this stage. They want that recorded. And you might be asking, well, why are we telling the court about this now, given what you said? Well, this is to counter any allegation by the prosecution at a later date. They may say it's recent fabrication. If we don't mention at this stage that there is a complaint, later on, say the pre-trial hearing, or indeed at the trial itself, when the allegation is made that the statement is not voluntary because there were threats or inducement, the prosecution will say, well, this is just all recent fabrication. They're just making it up now. They never once informed the court, informed that there was any complaint, right? The other reason is if there are any physical assaults, then it's important that there are steps taken. If they are remanded in custody, you may say that the defendant be permitted to visit the doctor so that a report can be made, photographs can be taken of any injuries. So particularly if it's just happened in the past few hours or within 24 hours. So these are things that I wish to share with you because they do not appear in any textbook or any checklist. Students, we are going to take a break so that you can complete your next task. Firstly, have a look at the screen. To assist you, we've prepared a chart of common objections and possible responses, and that is in Course Training Manual, page 44. So your next task is to review cases. The cases are of Chris Muntz, a jockey, Nancy Kissel, who has been convicted of murder, Carson Young, a tycoon who owned a football club, I think you know which one, and Deborah Nels, a tax consultant. Your assignment is to review these cases, which are in your materials in starting page 56 to 64, case volume 2, your course manual 2. I would like you to review them, and I would like you to prepare some points, bullet points, of tips that you would provide to an advocate for their first few bail applications. Right? What you glean from these cases. And in the next recording, we will have a debrief and go through some additional tips as well as a few other cases where we have been able to use some effective strategies to secure bail. When you first look at them, it's unlikely they'll secure it, but we use some effective strategies and they were useful. All right, so ladies and gentlemen, I don't want the recordings to be too long, so I'm going to stop this one now and then we'll have the next part in the next recording. Thank you very much for your attention. 2.2, Introduction to Bail, Part 2. In today's session, we are going to review the cases that you looked at, and we are going to outline the procedure for bail applications in NSL cases. Right, so the cases you were to review were involving the jockey Chris Muntz, Nancy Kissel, convicted of murder, murdering her husband, Farzan Young tycoon who owned Birmingham Football Club, and the tax consultant, Deborah Annels. You were to prepare a list of tips for advocates, your observations based on these cases, and it was going to help them when they prepare their first few bail applications. So let's have a look. The first case, bail. The key answer here should be that the rules of evidence do not apply to a bail application. What happened in this case? Well, for those of you who are not as familiar with the milkshake murder case, in Hong Kong, we have had a series for many, many years of very unusual, tragic, peculiar cases involving murder and assault. And I would say Hong Kong attracts a very unusual type of criminal cases. So with respect to Nancy Kissel, very quickly, she was married and she had 3 children living in a very luxurious lifestyle on the south side of the island. During SARS, her husband had arranged for her to travel to America, where she could be safe with the children. At that stage, SARS was unknown. And unfortunately, it appears now that she fell in love with the handyman. And when she returned, her husband had become aware of this. He had planned to divorce her. Now, this is something that may not be apparent from the articles that you read. The solicitors were given the fax of his office to send all important documents. However, they sent it home and she had received it. She panicked when she saw the word impending divorce. And that's when she had apparently hatched the plan to murder him. Her defense was that it was not murder, it was manslaughter. But very simply, in the case, she had managed to get sedatives and drugs from various different doctors, and she had used it in making a milkshake. But she had the children also make the milkshake for the husband, and he had it with his friend. He then was very disorientated, and she then used an ornament to unfortunately crush his head. Subsequently, she went to purchase rugs and essential oils to hide the smell and have his body rolled in this rug and taken by the staff to the storeroom. It's unclear what she was planning to do, possibly ship the body overseas. This is something that, having spoken to my colleagues who were formerly head of organized crime, they said that in their experience, criminals are very good at planning the actual crime, but not what happens after. And in fact, the defense counsel had argued it was because of her actions later that shows that the murder wasn't planned. You take what you can from that, but ultimately what happened in this case, she had then argued at trial that she was a victim of sexual abuse and long-term physical, mental, and sexual abuse from her husband, and that diminished her responsibility. However, at the bail application, her counsel had argued that she was stable and fit for bail to be secured on her behalf. She was also not a flight risk, and on that basis, she should be granted bail. Subsequently, at the trial, the prosecution then used the evidence at bail, saying that you can't have it both ways. You can't say that immediately after the commission of the offense, she is stable and fit for bail and is not a risk because of any mental condition, but then at trial argue of diminished responsibility. So what's the tip for students? Be very wary of discussing any matters at bail unless you have full instructions. So keep your bail application short, crisp, and to the point. Next, let's look at Chris Muntz. So this was a jockey, and he was charged with basically corruption by the ICAC, a conspiracy to accept advantages. Now, he was originally released on ICAC bail, and then he applied to court. Now, the curious thing about this particular case was his whole family, his whole life was in Australia. He was an Australian jockey visiting Hong Kong to compete in the races at the Jockey Club. So clearly, he was a flight risk, and clearly, he had very little to lose by not returning to Hong Kong for the trial. But Mr. John Massey, who we have known for over 30 years, he put forward an argument that switched the mind of the district court judge and allowed him to lift any travel restrictions. He said basically that Muntz would not abscond. He would travel to Australia, number 1, to compete in the Melbourne races, and number 2, to be with his family, but he would return to Hong Kong. And the primary reason he gave was that he had to appear at the Jockey Club inquiry. And if he failed to appear at the inquiry and clear his name, he would be banned from competing internationally, and that would be the end of his career. And it was that single point that had persuaded the court to allow him to lift the travel ban and for him to travel, because his cash surety and cash bail was 100,000 for cash bail and 100,000 for surety. Wasn't that substantial given the amount that he had potentially could win on his races. So what I want you to be aware of is that you need to think outside the box. And on that point, I want to share with you one case where my chambermate was representing someone who was charged with an offense under the SFC ordinance. And they were outside the district court waiting to attend the hearing, the bail application. And his client had to go and answer a phone call, and the client said something along the lines of, yes, I was in Indonesia last week. And so I haven't been able to follow up, but I'm back here now and I can follow up. Now, clearly it's not polite to eavesdrop, but in this case, counsel said to the client, could you please explain? I apologize, I overheard you mention Indonesia. Were you in Indonesia last week? He said, yes, I was there for a business trip. And I received a call from the ICAC about this case. So I just took the next flight and appeared. Very useful. It's not in the instructions. The solicitors didn't ascertain that information. The client didn't volunteer. So what did this counsel do in their hearing? Say, Your Worship, he's not a flight risk. Very clearly, he has no history of absconding. But in this particular case, he received a phone call from the ICAC last week when he was overseas in Indonesia. And he took the next flight and arrived in Hong Kong. He arrived in Hong Kong to face these charges. Your Worship, this is a very clear indication that he is unlikely to abscond and that he will appear at the next hearing. And very simply, he was able to secure bail, and that case resulted in an acquittal ultimately. So what I'm saying is, think outside the box, be aware, keep your eyes, ears open. All right. Next case, Annells. Wow, that case really managed to get some of the solicitors and barristers in a very difficult position, and that was Mr. Kevin Egan and Mr. Chris Morley. They accepted the documents that she gave to support her bail application, and it appeared that they were bogus. And it was the police that then investigated. So what lesson do we learn from that? Scrutinize your documents. Check. You don't always have to cross-examine your own client, right? But you do have to say to them, it seems unlikely that the court will accept that you're able to raise $6 million in cash bail, given that your salary is only $30,000. So there's nothing wrong with you leading a chain of inquiry and saying to them, and this is how you preface it, the prosecution will raise an objection, or it's unlikely the court will accept this. You don't have to say, I don't believe you, right? You have to say, performing my duty, I have to explain to you what opposition you're likely to face. And that's how you preface it. That is effective communication skills with your client. Now, the final one was Carson Yeung. Well, he tried many, many times to secure bail, and I think we provided you with two of the examples. One was with respect to the funeral in Shenzhen. And ultimately, the prosecution said, well, he's not very close to his father, and the court accepted that and didn't grant him restrictions, even though he was able to offer $8 million, which is obviously a substantial sum. In the next recording, I give you an example of a cash bail which amounted to $55 million. Initially, when they offered $30 million, the court said it's petty cash for that person. So be aware of different perspectives, be aware of different amounts. Right. So what I'd like to do now to end this particular session is to give you a brief outline of the procedure in NSL bail applications. Right, let's now move on to bail applications for alleged NSL offenses. I'll be referring to two pages, page 8 and page 25 of Course Manual 2. So with respect to alleged NSL offenses, the relevant article is Article 42, subsection 2. This overlaps with Section 9G1B, right? So Section 9G1B makes the risk of committing an offense on bail a reason for refusal. Article 42.2 deals with the risk of an accused committing acts endangering national security if bail were to be granted. So NSL removes the presumption in favor of bail. The starting point is that there is no bail to be granted. The threshold for grant of bail is higher than under CAP 221 scheme. So basically, there is no bail unless there are sufficient grounds to believe a violation will not occur. I've included Article 42.2 in your materials. I'll just read through it so that we can see where the emphasis is. So no bail shall be granted to a criminal suspect or defendant unless the judge has sufficient grounds for believing that the criminal suspect or defendant will not continue to commit acts endangering national security. And the case, this particular section comes from paragraph 53B in the case Lai Chi Ying, 2021. So let's look at the procedure for bail application in NSL cases. 42.2 creates a specific exception to the Hong Kong SAR rules and principles governing the grant and refusal of bail. NSL 42.2 imports a stringent threshold requirement for bail application. So the judge must first decide whether they have sufficient grounds for believing that the criminal suspect or defendant will not continue to commit the acts endangering national security. The judge must consider everything which is relevant. They must consider the possible imposition of appropriate bail conditions. In the event that they take the view that the defendant will not continue to commit acts endangering national security, then it reverts to section 9G2 CPO to see whether or not there's sufficient grounds. So under 42.2, sufficient grounds question is a matter for the court's evaluation and judgment. There's no involvement or the application of the burden of proof. So very simply, we have a chart here. If you look at this column, if having taken into account all relevant materials, the judge concludes that they do not have sufficient grounds for believing that the accused will not continue to commit acts endangering national security, then bail must be refused. If, and we turn to the other column, if on the other hand, the judge concludes that taking all relevant material into account, they do have sufficient grounds, the court should proceed to consider all other matters relevant to the grant or refusal of bail. In other words, the normal procedure for applying the presumption in favor of bail. So they will examine whether there are substantial grounds for believing that the accused would fail to surrender to custody or commit an offence whilst on bail. And it's not limited to national security offences or interfere with a witness or pervert or obstruct the course of justice. Once they've considered that, then they will consider whether or not there are conditions that they can impose which are aimed at securing that such violations will not occur. Then they ought to be imposed. And again, you may look at the case of HKSAR and Lai Chi-Ying. So ladies and gentlemen, this now concludes what I would say is the nitty-gritty, the law, and the detailed information for bail application. The next few videos take you to the steps to prepare your bail application. We will watch 5 different types of bail application. We will also provide you with learning tools and speaking tools, as well as speaking notes on how to deliver them and cover the communication skills that some of you have asked for, as well as others that we feel will be of benefit to you. So ladies and gentlemen, thank you for your attention. We now move on to the actual preparation and performance of bail application.
All right, everyone, welcome back to lecture 2.5. It's still Holden and myself. Now we're going to go through volume 3 now, and we're going to take you to the bail checklist like we promised that we would in 2.4. So we'll bring that up for you now. All right, so this checklist, when you're preparing for both your exercises, is something that is useful for you to use because it just puts everything down very neatly and shortly in front of you so that you've got the information all to hand. So we look at it very quickly. So the first page, quite straightforward, the case number. Now, remember, if your case is a fresh case, a new case, which they will be, that's why you're applying for bail, you will not have the case number yet. And you probably won't get the case number until the morning that you go to court. So don't be too worried about that. If it's an old case and you're going back again after 2 or 3 hearings, then of course you will have the case number, then you can write it down. So don't be too concerned if you haven't got the case number, you will get it if it's a fresh case. If it's an old case, you will have it already. Name, date, the court you're going to, who's the instructing solicitor. Now, the court is very important because don't think it's something funny or something that won't happen, but sometimes people do go to the wrong court. And it has happened to experienced counsel before and solicitors that they thought their case was in Sha Tin, where in fact it was in Kwun Tong or vice versa or someone else. So make sure you have the court in written down correctly. Any outstanding cases. Now, this doesn't mean you or, as in, oh, how busy am I? How many other cases do I have?
Outstanding case.
Yes, or this is a wonderful case. Do I have any brilliant cases I can talk about? What this means is, does your client have any other cases in other courts which are being dealt with at the moment? All right. Because if there are, then you will probably want, no, not probably, you will definitely want those case numbers. All right. You're only interested in those that have gone to court and have a case number. All right. If it's still at the investigation stage at the police, you need not worry about it. You want to know about it, but that's not technically an outstanding case. An outstanding case is once it's gone to court and it's got its case number, is going through the court system. All right. Personal details, all self-explanatory. All right. Documents, travel documents. Remember, these you will need to know about. And passports. How many types of passports? Have they expired? You want to know all these things because even if they're expired, you still have to hand them in. And this is in particular if you are pretty sure that your client will have to undertake not to leave Hong Kong. Right? Employment, income, previous education level. This goes to show what type of man, woman, client their background is. Right? Stability. So employment and how long they've been employed for is also very important because you're going to say it's stable and they've only been in the job 2 months. Right? But as opposed to, oh, he's been in the job for 2 years now. There's difference. All right. So that's very important. Local ties, involvement in Hong Kong. Remember, this is all important relating to absconding as well. Is he going to abscond? No, because he's got all these local ties. He's got property in Hong Kong. He's got to pay the mortgage, etc., etc. His whole family's here. All right. Then we move on to the offence itself. Remember, you want all these important matters, in particular, confession, any caution statements, admissions. So confession, caution statement, admissions, they all sort of go hand in hand. Will he challenge the voluntariness of them? Right. What's the bail he's on now, if any, police bail? Right. Generally, it's just a few hundred sometimes, and when they've got to go back. And what you think the likely objections are, or if you know you've spoken to the prosecutor, remember you always try to speak to them beforehand, then you can write them down. And again, you can see all there in the form, all the information there. So previous records of absconding. If he hasn't got any, even better for you. Just because he has a previous criminal record doesn't necessarily mean he won't get bail. But you want to look to see if there's any similar offences or if he's absconded before, because you may need to get an explanation. Why did you abscond on that last occasion? What happened? So that you can give an explanation to put things into context. Right? Other suspects still at large. Now, let me ask you, Holden, how does this affect the bail application?
Well, if there is multiple defendants involved, or accused, I should say, involved in a alleged crime, and they are still trying to locate those persons, of course, there might be concern that your client will go off and then liaise with them and potentially assist in allowing them to continue to abscond.
Yeah.
I mean, a bit of a long shot sometimes. And of course, this could be met with a explanation from the defense, particularly if they don't know the other person very well or have clear ties with them. But this is a concern that's raised, of course, obviously depending on the nature of the crime and if there are actually other suspects at large.
Yeah. So, I mean, of course, if I just go back a few, lack of local ties, no fixed abode, less likely to get bail in Hong Kong, because how can we find you if we need to find you? If your client just sleeps on the streets, then you're going to have a problem. That's no fixed abode. So you need a real address, right, that you can offer up with, confidence that your client is going to be found at that address, right? If we just carry on scrolling through, these are all, as you can see, very straightforward matters, bail condition. So you can see that this bail condition, complaints generally are against the law enforcement agency. So is it the police, is it customs, ICAC, is it immigration? Have they been threatened, induced? You want a record of that. You won't necessarily inform the court of that, but you want it for your own record, so you know what your client is saying at first instance. And then eventually, if they're remanded, if it's police custody or jail custody.
And you could put down the dates of the remand as well, just to keep an accurate record of that.
Yeah, that's very important. Dates are always important. Here, if they're granted bail, make a note yourself. Sometimes, especially counsel, make your own note, because sometimes solicitor may not make a full note.
Yes.
So you will need your own note, especially if it's likely you're going to continue to represent the client for the remainder of his criminal proceedings, right?
Yes.
And surety, relationship with the defendant, occupation, the income, etc. Right? Anything else of note. Right? So that's the bail checklist, and we will encourage you to use that.
Yeah.
Now we're going to move on to the annotated skills guide. We have put that in there for you. That's the skills guide itself. Right. Now this skills guide is the document that your trainers will use in your small groups to give you feedback. And there are numerous headings in it. Now, they're not going to write notes next to each and every single one of them. They may tick one or two of them. They're going to give you broadly their feedback. And it's going to be on this form. And you will get a copy of this form eventually after each small group, so that you have a record for yourself of what your feedback is and your performance. And of course, your mark. You will be given one feedback point, and hopefully you can take on board that point and improve on it. Now, I'll just go through it very quickly. The first few, of course, got to be relevant. You got to know your facts. You got to know the issues. Demonstrates forensic skills. So what tends to happen is that we deliberately, and I emphasize the word deliberately, will put errors in your papers or put contradictory matters in your papers so that you can pick them out, right, and inform us. That's called forensic skills. Are you meticulous enough to spot certain errors, right? So don't think that a typo is there because we have been careless. There are typos in there deliberately, or there are figures that are in there and that are incorrect, for instance, deliberately, right? We always do things for a reason, right? And this, of course, also covers me for when we have made a real typo, but I'm not going to admit that. All right. So can you anticipate questions from the bench? Your structure, of course, we've given you the different types of structure you can follow. So be careful when we say structure. Obviously, there'll be interruptions, but you don't want to be jumping around too much. You want to finish one box, as I say, and then move on to the next. That's what we're talking about when we're talking about your structure. It's got to be cohesive, all right? Suggesting the appropriate bail conditions. Remember, don't overburden your client. Make sure that they fit the facts. They meet the prosecution objections, right? Concise and precise. Remember, you've got 5 minutes only, so you've got to be to the point, pretty sharp. You will get additional instructions. That's the fun of the game, right? We will sometimes give you additional instructions uploaded on Moodle before your small group, and or very likely on the day of your small group, just as you're going into the room, you may be handed a document.
Which is very realistic.
Which is very realistic.
It prepares you for real life.
Yeah, it does happen.
Yeah.
So you've got to be able to quickly deal with that matter. And then you have to bear in mind, not everything we give you is relevant. Are you able to filter? What do I need really from this? Is it relevant? Right. So that's what we're testing you as well. The remaining parts are all stylistic points. Speaking at appropriate speed, speaking clearly, so no mumbling, eye contact. Can you put a positive spin on your facts? We're not telling you to make things up. All right, it's very different, but can you try and put another light on it, give another explanation for it? Court etiquette, ethics, we will deal with that in the third lecture. And at the end of the day, overall, have you been effective in persuading us to grant or not grant bail? Right. As I was saying, if you read on through the volume, page 15, these are the structures we give you in volume 3, so you can look at that in your own time, 15, and then we then have the quizzes. So the quizzes, we ask you to look at. Remember, you only had to submit them per group, and we have looked at them. And as you can see, some of the recordings are very old. Doesn't mean they're irrelevant, right? And some of them have been updated, in particular, the final 2. So the questions were more or less the same for all 4 quizzes, but let's go through them. So the first one that we had was John Wong, and the counsel in that was a very experienced counsel, Mr. Alexander King, senior counsel. And when I was a pupil, he was in the same chambers. Unfortunately, he passed away quite a few years ago, but a very charismatic counsel and a very, very good counsel. And he was in front of now retired Deputy High Court Judge, Mr. Gary Talentire, also a very, very nice fellow as well. Now, if we go through that demonstration, John Wong was a robbery case. And so robbery, and if you look at it, it seemed to be an armed robbery. So quite a difficult case to be dealing with. Now, if we look at the first question, how did the defense counsel meet the prosecution objections to bail? Well, if you see, he opened very briefly with a general discussion about bail, but eventually he met the prosecution objections with his bail conditions at the end of the day. And that's generally what happens a lot. We tell the court, these are the conditions we offer, and hopefully they will allay your fears. So that's how he meets them. Now, conditions of bail, well, always cash, $5,000. His surety was his uncle, Mr. Ho. You remember $10,000, and there was a bit of fun about strip club. He could report to a police station and not to leave Hong Kong. Now, generally with reporting, what you need to remember is if you offer reporting, you must ask your client what is the most convenient police station for him to report to, how many times a week he's willing to report, and the hours. Generally, you either go morning, afternoon, evening. If in the morning, you would generally have something from 9 a.m. till 12 p.m. Afternoon is very rare. I very rarely see 1 till 5 p.m. But generally, you will more likely see 9 a.m. to 12 p.m. or 9 a.m. to 1 p.m. And then in the evening, what you will always see more often than not is 6 to 9 p.m. So I want you to make a note of that, right? Those are the general times when it comes to reporting. Pick the police station nearest to your client, which is most convenient for him.
That may be their home or it may be their workplace. You want to, of course, get those instructions from your client as to which one will be easiest for them to go to.
All right. Now, the structure adopted, you can see, try to deal with the objections. This is many years ago, so he emphasized the fact that the defendant will not plead guilty. And then he dealt with the criminal record, background, and then the conditions. All right. So you can see his structure is similar to one of the ones that we have suggested to you. When you transition, what do we mean by transition is when you move from one area to another area of your application. And you can see that in the first the demonstration, he says, can I turn to the prosecution objection? So he just uses the phrase of what area he's turning to let the court know, I'm going to deal with this now. All right. It's just a very simple way. There's no magic to it. If you can deal with the background of your client, I now move on to my client's background. If you can deal with the bail conditions, I now move on to the conditions my client can offer. Right. Any relevant concessions he made? Of course, he said he accepted the offense is serious. Robbery is serious. All right. Robbery is serious. If I go back a step, the weakness in the case was the similar criminal record. That was the theft. And he negated by saying that it was dealt with by only $3,000 fine to try and show the degree of seriousness of the matter. So he didn't say it was trivial, but he's saying, listen, it was only a fine. That just shows that it was at the lower end of the scale. So he's implicitly informing the court it's not as bad as it appears to be. Okay, so putting a positive spin on the facts, you can see that he didn't really address the facts because the facts are quite difficult to deal with. And also, perhaps he didn't have time to have a full conference with the client. So he stayed well away from that and tried to concentrate on the background of his client and also the conditions that can be offered. So that is a tactic. There's a deliberate strategy sometimes adopted by counsel to try and turn things in their favor as much as possible. He didn't use three phrases. I mean, but one of the phrases he uses, not the type of offence where bail is refused to be granted. That is, sorry, not the type of offence that, as of right, where bail is refused to be granted. So he's talking about the robbery. He's saying to the court, just because it's robbery doesn't mean he can't get bail. So this was a very good phrase to use. And then when he's talking about absconding, there is nothing in his history or background. Right? Is also a very good phrase you can adopt when you're trying to suggest that he's going to reoffend or he's going to abscond. All right. Point 9, you see his pace is very deliberate. It's not very quick. The vocabulary he uses is very clear, simple, he's audible. And though he has a lectern with notes, he tries to maintain eye contact with the bench. And when I say eye contact, I don't require, or we don't mean that you must stare incessantly at the bench, right, without looking at your notes. No, of course you can look at your notes, but you must at the same time be able to keep, from time to time, eye contact, see what your tribunal is doing. And of course, interjections from the bench. Well, there was only one that was about the joke about the well-known strip club, and he met it with another joke. Right? Small senior counsel can get away with cracking jokes in courts. I don't advise that you do it.
Don't do that now.
When you're green and fresh. But when you get to sort of my age and you've been doing it long enough, then for about 20 years, then yes, you can crack the odd joke too. All right. Now, quiz 2, Ma Manxing. You'll note that it was Lawrence Locke QC with his very deep voice, and this was a very, very old recording, and this was a High Court bail application. So you'll note that it is in chambers. Any High Court bail application in chambers is unrobed. So he's not robed deliberately. Now, we don't know what the prosecution objections are. Why? Because they were being in an affirmation form. The difference between High Court bail and bail in magistracy is that there have to be affirmations filed by the defense. The prosecution will put in writing formally what they object to, and then your client prepares an affirmation and will attach documents which are appropriate. Now, the conditions he offers were $4,500 cash. Now, you might say, $4,500, that's a bit odd. Why not 4,000? Why not 500? Remember, it's what your client can afford and is willing to offer. So if it's 4,500, 4,000, always in multiples of 5, right? So not 4,200, right?
Not $4,525.
Exactly, yeah, 4,500, 5,000, right, and so forth. So surrender all the travel documents, not to leave Hong Kong, and report to Wong Tai Sin police station, right? And not to interfere with prosecution witnesses. So those were the conditions put forward. His structure was, first he introduced the purpose of the application. So he told them that this is an application for bail, right? And then he immediately pointed out the main issues of the facts. And he actually immediately highlighted the weaknesses of the Crown's case as it was then. So slightly different. This is what this is about. Here are the weaknesses in the case, right? And then he transitions eventually in regard to the conditions. So he doesn't say bail condition in regard to the conditions, because it's taken as when he says in regard to the conditions, he's talking about bail. And he deals with the weaknesses. Remember, he states that although the defendant was at the scene, there was insufficient evidence to connect the defendant to the weapon or wounding. And what did he do? He used the prosecution's own documents against them, their own allegations against them, right? Which is always helpful. If you can use the other side's documents against them, right, you become a bit more persuasive. And if you look also, he accepted that the defendant was at the scene. So he makes that concession. Remember, you've got to make concessions where appropriate. Yes, he was at the scene, but he says, but just because he's at the scene, so what? And following on from that, you can see the phrase he uses, mere presence does not amount to criminal participation. So having conceded, he then goes on to say, but let me explain this concession, right? In fact, he's quite forthright. He also says there's not an iota of evidence implicating the defendant. So he's quite strong in his wording. Of course, he's Lawrence Locke QC, so he can do that. I wouldn't go as far to put any case so high. All right, so be very careful. Again, his pace and his use of documents, his audibility, his ability to use all these matters, right, helped his delivery. Right? He was not in a rush. And you can see that in the first 2 demonstrations, the vocabulary has been simple, effective, very professional. And you can note that there's no colloquial terms at all. And that, affects your delivery and submission immensely. There were no real objections or interjections. Right. Holden, you want to look at number 3? Sure. So our Spanish. If you watch the video, you will have noticed yours truly was the defendant. And I was having a bit of fun. Of course, in real life, the client wouldn't do that, but it was a demonstration and we were having a bit of fun. All right.
So procedure adopted for plea. There was no plea taken here. So there was that doesn't come into effect on this one. What request did the prosecutor make? They asked for no plea to be taken and an adjournment for 6 weeks' time. And when we're considering what different approach might the prosecution consider in handling this case, obviously there's legal advice to consider dealing with the matter in an alternative way. And if you look at number 4, what request might the defense make to the prosecution? Obviously a bindover is what's being considered here as an alternative way to deal with this case. The previous conviction was read out and handed up on this occasion. That is often done. Oftentimes the magistrate may be asking for a copy of the criminal record as well. And so the prosecution will always have a copy, and they will often hand that up. As defense counsel, of course, you should be making sure that you take a look at that before the hearing. So how did the counsel respond to the questions from the bench on this occasion? Simply by answering directly.
He doesn't beat around the bush.
He doesn't beat around the bush, yeah.
You need to be in a position where you can say to a judge, yes, no, this is the answer, because. And he does that directly. And where he doesn't, he does say, may I have a moment to take further instructions, all right? Because if you don't answer, it's like you, if you ask me a question in a lecture and I don't answer it, you may stay silent and dare not ask me again, but it'll still be in your head. Why hasn't he answered my question? Why hasn't he answered my question? And you'll lose focus. Yeah. Same with the judge, except the judge will ask you the question over and over again. And your small groups, your trainers will ask you over and over again until they get the answer. So be direct, answer them, right? And if you need to get more information from the answer, just say, may I have some time to take instructions on this matter, all right? So bear that in mind.
It's very effective when you're direct, is what I would like to add for the next point there.
You saw that it was, Mr. Richmond was involved in that. He was also a very experienced counsel as well. They weren't really, the conditions, as you can see, they're quite similar. Not to interfere, not to go to the location. Not to go to the location has obviously become more prevalent in the past few years, given certain situations Hong Kong have gone through. So do not be surprised if you hear in real life, oh, you're not to go to that parking shop, you're not to go to that supermarket, drugstore, etc. Transitions that were used, there weren't really any. And again, you can see that their delivery is always effective because of the pace and audibility. I mean, these are two key stylistic areas that I keep banging on about, because you've got to be heard, this heard, so that they can take on board what you're saying. They need to understand what you're saying. They've got to be able to take a note of what you're saying. So if you're going 100 miles an hour like a Ferrari, it's very difficult to take a note. So if you're one of those people who speak very, very quickly, there's no point me saying to you speak slower, because it's difficult for people to speak quickly because it's natural. So what you then have to do is be able to pause at appropriate moments to give the tribunal time to take down the note. All right. So that's number 3.
Just one thing I would like to add as well, for the not to go to the offense location. Yes. You always want to bear in mind when you're dealing with your particular client whether this condition is appropriate for their circumstances. For example, the offense location may have been the MTR station, and maybe they need to take the MTR to get home. It may be the situation that they need to go to the specific place because of their work, for example, or where their child goes to school, they need to go there to pick up the child, right? So you need to bear these factors in mind and think about how realistic it is for your client. The prosecution may be suggesting it, but you may need to clarify the matter for the court and suggest that it would not be an appropriate condition on certain occasions. On other occasions such as this, it's perfectly fine and the client would be willing to do so as long as those are your instructions. So there's no issue, but sometimes there may be issue with this and you need to be careful.
Right. So we'll move on to the final demonstration. So we had 2 defendants in this case, and you can see that the courtroom was loaded with lawyers and actors and volunteers. So we can see that the prosecution were opposing D1's bail, but not D2's bail, right? Because they say that the first defendant had committed this current offense whilst he was on bail for another offense. So that's generally very serious, right? That generally, if that occurs, there's a grave chance of not getting bail, because it suggested, well, you committed bail last time on an offense whilst on bail last time. What's to stop you doing it again if I give you bail, right? So there was no objection to the second defendant's bail. Now we can see that in this case that this trial was going to be adjourned for 12 weeks, all right? And so a very long time away. So it would have been keeping the first defendant inside for a very long time. And so the judge asked for the brief facts. He wanted to know what basically the case was, really what the allegations were, and basically the type of evidence and number of witnesses that would be involved. I mean, that's all in the brief facts. You'll see that when you do your small groups. And when it came to dealing with D1, so we had Mr. Raymond Pierce for D1, very experienced counsel as well. He was also taught on this course as well with myself and Ms. Rejwani, very experienced counsel, very good teacher as well. And you can see throughout the performance, he has a very dry sense of humor as well, because he's Scottish. And I say that in a nice way, of course. But you can see he tries to meet the objections to bail, in particular, the most pressing concern, commission of the offence whilst on bail, by explaining the circumstances of the previous offence. And if you watch the demonstration, it was about the demonstration to save the dog, right? So he tried to put everything into context to say, well, listen, this is what that case was about. And then eventually he went on to explain how that case was dealt with. So putting things in context is very important, because not everything seems as it is if one side says it. Remember, there's always 2 sides to a story, 2 sides to a coin. You've got to see the flip side as well to get everything in its proper context. So he does put forward conditions of $10,000 cash, not to interfere with the prosecution witnesses, and report to the Aberdeen police station. He asked not to leave Hong Kong except for a few days in Macau, right? And remember, the defendant was meant to be studying Buddhism. And the judge asked, well, Macau, isn't that, the mecca of gambling? And this is where Mr. Pierce's dry sense of humor came in, saying it would be a good test to see if he had reached, I can't remember the phrase, reached enlightenment. So again, very experienced counsel, very dry sense of humor. Again, if you're just starting out, try to keep the humor away. It's not always the best thing to do. You've got to gauge your tribunal. So again, when he transitions, if I may move on to the seriousness of the offence, or moving on to the next objection. Very, very simple. Remember, no magic to it, no magic to it. Just tell the court where you're going next. Remember, it's a signpost. Again, he accepts that there was a serious offence, indecent assault, he accepts that, and he obviously accepts that there was touching, but it's accidental, all right? And he concedes that drunkenness is not a defence, because he says, well, the client is drunk. Is that a defence? No, we're not running that. And he quotes Mayersky, the case, but he puts it into context to say why drunkenness is important. And he explains, this is the one case where he does reveal the defence. He says he had a bit to drink, he was unsteady, lost his balance, and accidentally touched the complainant, and accidental touch will be the defence. He confirms that, because in indecent assault, it's either an accident or it didn't happen, or it was consent. All right, it's one of the three. So he's not hiding anything, because there's nothing to hide really in this case, and he's got firm instructions on it. So we were talking about asking for time, or what happens when you get instructions, and you'll see in the recording that Miss Rajwani, who's a D2, was getting lots of instructions from her instructing as well. And you can see that they always faced the court and said, if I can have a moment, and then they turn to talk to their instructing, and then they tell the court after that, I'm grateful for the time. So they ask for time, they thank for time. They're all very calm about it, and they whisper, well, what is it? Oh, what is it, Mr. Sutton? What do you want to tell me? There's no need for that. Yeah. They're your instructions. The whole court doesn't need to hear it there and then, right? Because you may not use all of them. So you can see, and they talk very quietly, and they're very calm about it, and they're not ruffled. Never be ruffled, even if you get bad news. Right, you've got to be calm about it, even if it is bad news. Yeah,
don't look at your instructing solicitor as well with a bad face and say, "What are you telling me?" You have to. Everyone has their eyes on you at that point in time, and the courtroom is total quiet. So, as Kevin mentioned, keep it low, keep it professional.
Yeah. And of course, we eventually find out that the bail of the first defendant in the previous case wasn't revoked, and then there was handing up of the medical reports in relation to the assault case. And the 5 phrases you heard: "I'm obliged," "May I have a moment," "Most grateful," "Further facts may shed light on a fuller picture." All right, so this phrase was used by Mr. Pierce. "May I have a moment just to clarify that point, sir?" So that was used by Ms. Rajwani. So these are all phrases, professional phrases, etiquette phrases. "Further facts may shed light on a full picture" is not one that you use all the time, but it can be used. It's a stylistic phrase when you want to say, listen, there's 2 sides to a coin here. Let me explain to you my client's version of events. The others are more formal phrases you can use, and they're all about asking for time. So you see, there's not one set phrase. And again, you can go back to the glossary given you, and again, pick one that you feel you're comfortable with. Right? Remember, they're all stylistic. Okay, so that covers everything for 2.5.
By the end of this recording, you will understand how to plan, research, and prepare a bail application. In the next recording, we will demonstrate how you can present your bail application in court. For this session, you will need the following documents. You will need Course Training Manual 2, pages 13 and 14, pages 30 to 45. Right. You will need Course Training Manual 3, the bail application checklist on page 4 to 8, the record of bail proceedings, page 9, skills guides, page 10 and 13. Before we start, please review the outline and objectives on page 3 of Course Training Manual 2. Let's start. I would like you to have a pen and paper handy. Normally when we have the session in a large group, the students will have their folders, and on the inside cover they would have this sheet of paper. This sheet of paper is for tips and tools. As we go through each recording and as we go through the large group sessions together, I and Mr. Wong will share with you lots of tips, lots of tools. They're called practitioner's tips. These are tips that you cannot necessarily find in any textbook anywhere. They're things that we have built up through our experience. So have that checklist and have a list of the tips and tools, because they will assist you and enhance the way that you conduct your advocacy. Right. Now that you're familiar with the law and procedure,
Can you visualize yourself in court making a bail application? Right. So now what I'm going to ask you to do is something that I'd like you to do, even though I can't see that you're doing it. I'd like you to shut your eyes. Right. Are they shut? Now, I'm going to ask you to imagine that you have passed the PCLL first time round. You have worked as a barrister or a solicitor or in another field. You've been incredibly successful, and you have been invited to be a deputy magistrate in the magistrates' courts in Hong Kong. You have been promoted. So congratulations. Now you can open your eyes. Imagine yourself as a magistrate sitting in court. So the first thing I think that's useful for students is, before we even go through all the steps, is I think it's important to visualize. Visualize yourself, visualize a bail application. What we're going to show you now is the case of HKSAR and Carmen Lee. This case is a case where the duty lawyer service represents Miss Lee. What I'm going to do first is to invite you to read the charge sheet, and I'm bringing the charge sheet up on the screen now. And as you can see, Miss Lee has been charged with theft, contrary to Section 9 of the Theft Ordinance, Cap 210 of Laws of Hong Kong. When the charge is read, it will say, Lee Carman, you are charged on the 18th day of September this year at the shop Time After Time at number 767 North Point Shopping Arcade, 1879 Java Road, North Point in Hong Kong. You did steal one silver color clocked, which was valued at Hong Kong dollars 1990 cents, the property of Time After Time Company Limited. Right? Now I'm going to invite you to pause the recording and read the brief facts. The brief facts are on this recording as well as in the link below to this recording. Have you read the brief facts? The next thing I'd like you to look at is the extract of bail recording. This document that I'm about to show you is a document that has come from court, and I'm going to show you the hard copy here. The original copy is actually 4 pages. There's a white copy, the yellow sheet. So one is for the magistrate, one is for the court records, one is for the defendant, and one is for the correctional services. This is the actual document that the magistrate has to complete when conducting a bail application. And as you are the magistrate, let's take a look at it. Let's take a look at this document, because this is the one that's going to help you prepare your bail application and help you understand what is in the mind of the magistrate when they are considering bail. You will see that the top column has whether it's granted bail, and if bail is granted, what conditions, and we'll go through the conditions. On the right-hand side, you will see bail is refused and remanded in police custody, or bail is refused, remanded in jail custody. And then they have to explain why. And the reason is because there are substantial grounds for believing that the accused would either fail to surrender to custody as the court may appoint, or commit an offense whilst on bail, or interfere with a witness, or pervert or obstruct the course of justice, or finally others. There may be other reasons that may trigger their concern. Now, you will see below that they have reasons to support this, their decision. That it's a serious offense, the nature and seriousness of the alleged offense, they have a previous record of absconding, they've previously absconded in these proceedings. May I just add here, if they have previously absconded in these proceedings, the chances of securing bail are practically zero. Unless there was some medical emergency, they were in hospital, they were unable to communicate to the court that they were unable to attend, then in those circumstances the court will receive evidence to support that and may consider it. But if they have absconded in order to avoid being detained, then it's unlikely they'll secure bail again. Lack of local ties. They appear to have no fixed abode. They are alleged to have committed this or these offenses whilst on bail for other matters. This is a little bit controversial because we have the presumption of innocence. So to have suggested that they have committed an offense whilst on bail, the terminology can be misleading. But what they're basically suggesting is that they have been charged or they have allegedly committed an offense whilst on bail. Now, they have a criminal record for similar offenses. Criminal record is a very important factor that the courts take into account when considering bail. And we will go through that in a little bit more detail. I'll show you some sample criminal records. There are other suspects at large. If this is a gang offense, or if this is an offense involving several defendants and only one has been arrested, the others are at large, in other words, they have not been arrested, there is a risk that this particular defendant may alert them. And so they may use that as a reason to detain them and refuse bail. The stolen goods and the exhibits are yet to be recovered. They may be hidden. All right. Now, the final category, as you can see, is the actual conditions. So in the event that bail is granted, these are the factors that these are the conditions that they may impose. Cash or surety, not to leave Hong Kong, surrender all travel documents prior to or within release from custody. Sometimes they don't have their travel documents with them, and your client may say to you, I have not brought my travel documents to court. You inform the court that may they have 2 hours or 3 hours, or may they have the opportunity to contact their relatives to bring those travel documents to court. And normally the court will say at 4 p.m. today. So then they allow them the chance to do that rather than refuse bail altogether. Surrender or to reside at an address given, that is commonly used if there is a case of domestic violence or violence between neighbors, and they need to separate the defendant from the family members. So they will request an address to be given, and that will be one of the conditions imposed. To obey a curfew. Curfew, that is normally common when it applies to youth, young offenders. So they will generally impose a curfew of, say, 9 p.m. to 7 a.m. And if they breach that, that will be a grounds for them. They've breached that condition of bail, they'll be brought back to court. Finally, they have the section for reporting. Again, it's flexible. The counsel will tell the court when is ideal and the location. If they work in Aberdeen but live in Cheung Kwan O, then they have to indicate that Cheung Kwan O from 6 a.m. to 9 a.m. are suitable to allow the defendant to report. So that's information that the court needs to have when they are considering the bail application. If they change their address, they have to give 24 hours notice prior, and not to contact directly or indirectly any prosecution witnesses. And of course, there is the others. Now, you are sitting as the magistrate. You have read the brief facts and you have read the charge. Would you at this stage consider granting bail? I'm hoping the answer is yes. It's a very simple case. It's a very simple case. At the moment, we do need some other information, for example, her criminal record and her background. But at the moment, it's a simple shop theft. The value is small, and it is unlikely that she's going to abscond for such a small amount. In any event, she's likely to get a fine if this is her first offense. So bail is likely to be granted. What are the terms that will be imposed? Why don't we watch, and you will see how the court deals with this very simple matter.
Good morning. Welcome to lecture 2.4. Mr. Slutsky and myself will be giving this lecture.
Good morning, everyone.
So hopefully before this lecture, you will have watched the recordings 2.1 to 2.3. They, of course, were not given by us, but were given by Ms. Vandana Rajwani. She was the founder of this course, so hopefully you will have taken on board everything she said, as she is a very experienced teacher and practitioner. So what we're going to cover firstly is we're going to look at volume 2, and we're going to go through how we get ready for our bail application. So we'll bring this up and we're going to share it on the screen for you. And we're going to start at page 35. All right. So here we are. It's our guidelines on how to research, prepare, and present the application. First things first, papers, right? We need papers. Now, do you think we get our papers before we see the client, or we see the client and then get our papers? What do you think? Mr. Slutsky, how does it work?
Hopefully beforehand.
Yes. Generally speaking, we will get our papers before we meet the client. Your competent solicitor will send them in advance, or even if you're a duty lawyer, you will get them in advance. It's just a matter of how much time you get them in advance. And that's why you see, as item number 1, we use the phrase skim read. Skim read is in particular if you do duty lawyer cases, because you don't get very much time. You may get maybe 2 or 3 minutes to quickly read the papers and then have to see the client. Maybe the client is in the cells. So that's why we say skim read. If you're privately instructed, of course, you have a lot more time and you'll be able to take your time to go through the papers meticulously. All right. Now, once you've read the papers, you've got to highlight all the salient points when it took place. So date, time, place, who are the characters involved. Prepare a very quick chronology so you in your mind are very clear of what's going on. Now, this is more likely to be a case where you're privately briefed. You've got more time. When, again, if you're doing duty lawyer, you'll have to arrange your thoughts very quickly in your mind. And this will come with practice. We don't expect you to get it off the bat, but once you do it long enough, if you do criminal practice, you do it long enough, then it comes almost second nature to you. All right. Now, number 3. Well, Mr. Slutsky, why don't you take them through this?
Yes. So you want to make sure that you identify the relevant charges that you're dealing with. Sorry, I have a little buzzing there.
Yeah.
You want to make sure you identify the charges the relevant charges that you're dealing with. Obviously, you can start by looking at the charge sheet, see what charges the people your client or respective clients are facing. And an easy way to start your journey into how you look at the charge and what you need to do with it is to look at the ordinance. Archbold is also a very relevant tool that you can make use of. You also want to identify the elements of the offense, see what the elements are, and that will help you to identify whether there's any defense available. If you're early on in the case, of course, and you haven't yet seen your client, you're going to be wanting to be thinking about what potential defenses are available from the documents that you have. So this exercise really should be you trying to point out what potential defenses there are. Of course, once you take concrete instructions from your client, you'll be able to narrow those potential defenses down. You also want to identify the penalties. And by this, I do not mean you look at the ordinance and you see a maximum sentence of 12 years or whatnot. You want to look at what the likely penalties are going to be based on the facts of your case. So that, of course, again, could be some assistance from Archbold. You can get some assistance as well from looking at case authorities, as well as Cross and Chung on sentencing. But you want to make sure that you're prepared to tell your client what the likely sentence they're looking at based on the facts of the case that they are facing. You also want to make sure that you prepare the case from the other side, from the opposing side. And the reason for this is it really enables you to prepare your case in a better way. If you think of things from the prosecution perspective, and you're the defense lawyer in this circumstance, it will help you to prepare your defense case a lot better because you will be able to identify the weaknesses in your case as well as the strengths in your case. When you look at it from the other side, from the other perspective, it helps you set things into perspective from your own side. So it helps you to be able to meet those issues that you will face when you actually make your application.
And of course, we always recommend that you prepare the other side's case first, because if you know what your opponent is going to say, then that immediately identifies the weaknesses in your own case. And those are the most important areas to recognize, because you will never get a perfect brief. There will always be a problem with your case. And that's why your client's been arrested. There's a problem with the case, right? So what you should always try to do is say, if I was the prosecutor, number one, would I object to bail? If the answer is yes, then what are the objections going to be that I would like to raise based on this particular case, based on this particular defendant? For instance, he may have numerous criminal records which are related to this offense or similar to this offense. So very important to know what your opponent is likely to say. You won't know what they will say, of course, until you hear them on the day of the hearing. But if they don't say it, then maybe the judge may, because you also have to think, well, what might the judge be thinking? So bear that all in mind. And this is all before you've seen the client. So there's a lot of preparation that goes into what looks like a very simple application. All right, now let's move on. So number 4, of course, goes without saying. The questions you ask are the ones that fill in the gaps. Identifying the prosecution objections. We've already said this, that you will have to anticipate what you think they're likely to be based on the facts that you have. All right, so that's very important. The application checklist, the bail application checklist we have, that is in volume 3, that's in the workbook. And that is a practical document. In fact, it was a document Miss Rajwani had when she was a pupil and has been using ever since in practice. And it's very helpful. We will go through that in due course. Mr. Satsuki, why don't you take them through 7 to 10?
Yes, well, 7, 8, and 9, they of course go together. You want to make sure that you analyze the facts. You need to think about them. You can't just read the facts and be ready to go. You're making an application here, and you need to be able to address the court on any aspect that may arise. And you want to make sure that you prioritize the issues, of course, that goes together with how you structure your argument. You want to make sure that you work out a logical structure to your application, one that flows nicely with an important factor usually addressed primarily, and then the less important factors taken care of later. So you want to think about how you can structure it in a nice way that will be easy to follow And the court will take note of those important factors that you want to address the court on. And the best way to prepare, of course, is a bullet point. You want bullet points in large, readable font. You don't want a script. If you write out your submission in full, I can tell you that you will struggle terribly. The reason for that is, of course, there's often going to be interjections from the court. You have to be able to address those interjections. And if you have a full written out script, you're going to struggle to come back to where you wanted to be, and where things will flow more ordinarily from the interjection that has arisen. So if you prepare your own submission in full, you're going to end up just sitting there reading a document and then getting lost in your notes. Prepare bullet points, make them in large fonts so that it's easy to read, easy to tick off and make sure that you cover each point that you want to cover, and you can come back to things as needed as you go along in your submission.
If we go back just slightly to structure, we do in our notes give you suggested structures. The important thing is that there's no wrong or right way of doing it. That's number one, because each practitioner has their own style. But more often than not, if there are objections to bail, they are generally dealt with at the very beginning of your bail application. Why? Because those will be the most pressing concerns for the court. So if you don't deal with them right away, there's going to be a question in the back of the judge's mind all the time until you address them. And then after you've addressed them, you can decide whether you want to go to the client's background, or if you wish to deal with the issues that arise from the facts first, and then eventually the conditions that you're going to raise for bail. Generally, the bail conditions that will be offered come towards the end, right? So we do have a structure in your notes for you to look at, and you can adopt whichever one you feel comfortable with. The other thing, already mentioned, bullet points. It is advisable that you do not write them out, because you can get very nervous when you get up and deal the real thing. And students, even in their practices, in past experience, get so nervous that they can't read their own handwriting. So if you type it in a nice big font, even if you're nervous and you have a lectern and you're standing back, you should still be able to read it clearly. So that's the important thing about your notes. If you write a script, when you do your practices, I can tell you now, as Mr. Slutsky has pointed out, you won't get through the script because our trainers have been instructed to destroy your flow, to interrupt you, to put you off track, because they want to test your flexibility, your adaptability. Can you answer me and continue with your application? And the best way to do that is just to have bullet point notes, because if you try to go back to a script, having been flustered and then euphoric because you've answered the question, you go back down and your head will go, oh, where was I? So that is a very important tip for you to bear in mind.
And that's what will happen in real life as well. So it's just preparing you really for what you're going to encounter when you get into court.
Oh, yes. We try to prepare you as best as we can. We can't prepare you for everything, but we try to prepare you as much as possible, because each tribunal is going to be different in how they approach their own court and the way they do things. All right. So bear that in mind. All right. We'll move on. So as we've said, those were just the basics. All right. So far. Now, as you can see there, the court's main concern is, if I give this defendant bail, is he going to come back again at the next allotted time? Or is he going to abscond? Right? You note that I use the word abscond, not jump bail, right? Not kick bail, not do a runner, right? All these colloquial terms, we have them in Chinese as well, abscond. It's very important from the outset to use the proper terminology. You will see a lot of colloquialisms in court, and especially in court one. Some judges will pick it up and say, excuse me, don't you mean abscond, not jump bail. Some courts are so busy that they let it slide. But it's a very bad habit to get into in the first place. We want you to learn the good habits right from the beginning so that you always appear proper and professional, because that's what we want you to go out and be able to look like, right? That's very important. So what do you need to do then? Well, you can't just say, well, oh, of course, sir, don't worry, he's going to come back, you know, I guarantee it. And you come back the next time and he's absconded, he's jumped on the next plane to Brazil or something. And the same judge says, well, Mr. So-and-so, didn't you guarantee last time he would turn up? Ah, well, you see, Right, a lot of explaining. Number one, you never, ever guarantee anything or promise anything to the court, right? You can say that the defendant undertakes to do something, and if he doesn't, that's his fault. But never, ever guarantee yourself, oh, I guarantee my client will turn up. I promise you will turn up. Very, very dangerous, right? You never, because you don't know what your client is thinking. And if you don't know what he's thinking, how can you promise on his behalf? So bear that in mind. All right. So what we need to do, answer the questions. We've got to reassure the court that he's going to turn up. And if we look at point 12, well, Holden, why don't you take them through the remaining parts there?
Yeah, well, of course, the most effective method is you want to weaken or cast doubt or undermine the prosecution objections. Think about it. If the prosecution is raising an objection, they're going to be there saying something to the court that sounds logical, most likely. And you need to be able to deal with those issues. If you just skirt away from it or you just ignore it, the court's going to have that strong objection from the prosecution in their mind. And you would not have done any benefit for your client. They're going to get their bail refused ultimately. So you want to make sure that you can find a way to weaken or cast doubt on it. And there's always ways to do so. So for example, if they say that they're likely to abscond, you might have plenty of evidence that your client has total strong local ties to Hong Kong. They grew up here, they have family here, they're working here, they're studying here, whatnot, depending on the circumstances of the case you're dealing with. But there's many ways that you could take the information that you get from your client and use it to counter what the prosecution is saying, to object to bail and suggest to the court that it shouldn't be granted. So there's effective strategies to do this. And you see here that we have showed the prosecution objections to be misconceived. For example, if they're saying that the evidence is strong, you might have plenty of information to say why there's gaps in the evidence, why, based on the brief facts, for example, and the evidence you've been provided, that there's another explanation for what has occurred. You can also say that, as I mentioned with regards to absconding, for example, that they have strong local ties. It's therefore misconceived that there's a strong likelihood that they will abscond or fail to appear. And you can also propose realistic bail conditions to allay any of those concerns. So, for example, surrender travel documents, have them reporting to a police station, perhaps several times a week. That would really alleviate any concerns that they're going to go anywhere. And you can also give other bail conditions, such as cash, of course, and a high amount value of cash might do some good to suggest that they will appear on the next occasion and at trial. So we have a quote here. When applying for bail, remember that your best chance of success lies in displaying such moderation and responsibility that the objections are made to look more unreasonable and unjust. So again, it's how you frame your answer to the objections to make it look like the objections are not reasonable and that they are unjust. And that by doing so, you will create a better picture for your client's position and enhance the chances that your client will obtain bail by being able to meet these objections in a strong and coherent manner.
Now, you have to bear in mind that sometimes you will get very difficult cases, and sometimes the evidence is overwhelming. Doesn't matter. What you want to try and do always is to try and meet the objections as best you can. And sometimes they could only be met with just the bail conditions offered by your client. Now, remember, such things as how many times you can report, how much money you can offer, they are all up to the client. You can't force it upon your client to offer $100,000 when they don't have $100,000. It's always, what are they financially capable of affording when it comes to cash bail, right? What are they realistically willing to adhere to? And if they aren't willing to adhere to, for instance, surrendering their travel documents, then it is incumbent upon you to advise them, listen, if you don't surrender your travel documents, the likelihood of getting bail is going to be slimmer because of the fear that you may abscond. So remember always, what can be offered is always up to the client. You can always advise what should be offered to enhance their chances, but you can never force them. All right, so that's very, very important. And remember, there's lots of conditions. Sureties are something which are important as well. So you need to be able to go away and advise on surety. So you'll need to go up and look up sureties as well. Who can be a surety and who can't be a surety? This is a common topic. Who can't be a surety is something very important thing that you need to be conversant with, because if you don't know who can't and you offer someone who can't, the court will pick you up on it, and it can be very embarrassing. All right, so please bear that in mind.
Yeah.
Right?
Other common ones are not to interfere with prosecution witnesses, depending on your case, of course, not to go to the offense location, curfew sometimes, yes, depending on who your client is.
Yeah. It all depends on the nature of the offense. And when you come around to doing your small groups 1 and 2, what we're going to try and do is try to give you as many offences, different offences to look at as possible, so you get an opportunity to go and research them, of course, and understand how different facts will affect applications differently. All right. Okay, let's move on then. So we're still talking about making our submission. All right. So now, when we are making the submission, you're going to be standing up. Remember, you always stand up. This is not a civil application where sometimes you're allowed to sit down. You'll always stand up. And in your small groups, you will have to stand up because we will be face to face with your trainers. Your heart will be pounding. You'll be shaking. Some of you may be sweating. Some of you may be about to faint. Right. All of the above are permitted except for the last one. It is forbidden to faint in your small groups, right? Because you still have to do your application, whether you like it or not.
There's no way out.
No way out, all right? It's easy to say stay calm, all right? We will give you a lectern of sorts, and it's always advisable to hold, as you'll see in the small group rooms, there are all tables. Hold the tables with your 2 hands in front. So if I stand up, you can just hold it here. If you're worried that you grip the table too hard and that you'll rip the table to shreds, put your hands behind your back and make your application, all right? Because your hands are the most likely tools to give you away that you are nervous. All right. So you have to be like a swan. You've got to be smooth on the top of the lake, but no one sees your feet paddling furiously below. So try and keep calm, because you need to project the confidence, and you will be confident if you know your papers inside out. You know what you're going to say. You've anticipated, or you more or less know what the prosecution are going to object to. If you're fully conversant with your papers, you shouldn't be too worried. Right. Go in there confidently and give it your best shot, because, as I've said before, you're going to make mistakes, and we will be encouraging you to make mistakes here rather than with a real client in the real world. All right. So knowing your facts, your eye contact will be very important. So if you have notes, as we've already said, bullet points, yes, very good demonstration. This is what happens.
And we take it away.
And we take it away, and we make you carry on without your notes. So try to maintain that eye contact. And why is it important to maintain eye contact with your tribunal?
You're trying to convince them, right? You're trying to succeed in your application. If you're sitting there, standing there, I should say, you better not be sitting, and you're like this, what kind of rapport do you have with the tribunal, right? How convincing can you be?
Yeah. The other thing is, tribunals are humans, so they all have facial features. So you'll see if they're nodding, if they're shaking their head, if they're frowning, scratching their head, because those are all non-oral, non-verbal hints to you. Hang on, he's not persuaded. Maybe I should ask him, sir or madam, I note that you're scratching your head. Is there something perhaps I can assist you with in my application? Or is there something perhaps that's not too clear? Right. So if you've got your eye on the judge, then you can pick up these little hints, which may stand you in good stead, because you can deal with it there and then. And that's why not relying heavily on your notes is also important, because you can see these things. And if you can deal with it, it improves your adaptability, your flexibility. Right. That's what you need to be able to do. Introducing yourself when you are in court. So in the magistracy, in fact, in all levels of court, you have to fill in an attendance form. All right. If you are a private brief, the duty lawyer service, a list of cases will be handed up to the court with the name of the lawyer. What we generally do is we just stand up if we're defending and we're doing the bail application, and we'll just say, sir, I appear for the defendant in this bail application, or I appear for the defendant, sir, and there will be an application for bail. Because the magistrate, the tribunal, will already know your name. So they will say, yes, Mr. Wong, yes, Mr. Slutsky. And so you say, yes, I appear for this defendant. Right? You will sometimes hear the phrase, may it please the court, right? Which is a very formal phrase to begin your application. Not, may I please the court, right? May it please the court, right? Because the court may not find you very pleasing at all, right? It's always, may it please the court, or directly stand up. So introduce yourself, just saying that you appear for the defendant and that you have an application for bail. Right? That's a very simple intro. You don't have to introduce the prosecutor, because the prosecutor would have already stood up and explained whether they object to bail. And in all your small group practices, don't worry, they will all be objecting to bail, and they will have listed out the objections. Right? So you don't have to introduce them. You can explain the structure of your submission, but sometimes it can take a bit of time. So if you want to do it, just do it very, very quickly. Just going back a step, you don't have to read out the charge again. Why? Because the charge will have already been read in open court to the client, and it will depend, of course, whether a plea has been taken or not, or if it's being adjourned. So you don't have to read it out again. You can mention the charge, in particular if you've got multiple charges, right? And you want to take issue with one of the two charges, or one of the three charges, of all the charges, for instance. But don't repeat the charge. For instance, don't say, oh, the defendant is charged with theft contrary to Section 9 of the Theft Ordinance, Chapter 210, because the magistrate would have said, yes, I know that has been read out. Get on with it, right? So don't read it out. In relation to your structure, if you want to quickly set out, you can say, very quickly say, sir, madam, I'll deal with the objections first, and then I'll move to the background, and eventually the conditions to be offered, for instance, right? So keep it brief, because you will only have 5 minutes to do your application during your small groups, and there will be interjections. So you want to time manage wisely, all right? As you can, if we move on, we're going to deal with, we've listed there's a simple structure, 4 areas to cover: prosecution objections, circumstances of the case, background accused, bail conditions. The middle 2 can always be swapped around, right? In fact, the top 3 can be swapped around, but it's probably more advisable to deal with the objections first, as we've already said. Okay, so 7 to 10. Alden, why don't you take them through?
Yeah, sure. We already discussed, of course, the importance of preparing your case from the prosecution perspective. So you want to be able to, of course, be able to respond to what they say. So the first thing is, of course, respond to prosecution objections here. You want to highlight the weaknesses in the prosecution case at this stage. And we say at this stage because, of course, depending on where you are in your case, if it's your first appearance, the client's first appearance, and it's the first application for bail, you may have limited information and limited documentation. So you don't want to be saying something in open court, taking a strong position for your client, when it may end up contrary to other documentation or other instructions that come from that documentation later. So you want to be able to highlight usually the broad weaknesses at this point in time, what you can see from the documentations you have and from the instructions you've been able to obtain thus far. And you want to identify the issues to be argued and explain the accused position on the charges. And again, this goes back to the point of how far do you go explaining the accused position and dealing with certain issues that are to be argued. It may be very limited at your initial appearance, your client's initial appearance, and you might not be able to go very far, but you might be able to at least somewhat deal with those issues. And it's important to do so because if the prosecution is objecting and it looks like your client's caught red-handed, and let's say your client has a perfectly rational explanation as to what happened, they forgot to pay, for example, walking out of the supermarket, and they have a clear defense on that in that regard, and they're going to stick to that defense. I mean, you could probably inform the court that this is going to be a defense and it's not a strong case against them. Also, perhaps there's an alibi, and if you have clear instructions of that at this point in time, you might be able to inform the court that your instructions are that your client was not there at the time. And again, this really depends on the facts of the information that you have in relation to the case. If there's CCTV footage you're seeing on the brief facts showing your client that location, even they're telling you they're not, you don't want to go down this road, obviously. So always bear in mind the stage you are at the case and what you can inform the court of that will not jeopardize your client going forward. You have to play this with a very fine line.
And what is important, of course, is remember at the initial stage, in fact, at any bail application, you do not have to reveal your defense.
Yes.
You do not have to. Now, some cases, Holden gave you an example there of the shoplifting, forgetting to pay. Some cases have very obvious defenses. So, for instance, if it's, for instance, rape, it's usually either there was no sexual intercourse or there was sexual intercourse, but it was consent. All right. There are some cases where it doesn't hurt to reveal the defense, but there are some cases where it's better not to. And generally, we do not reveal our defense at the bail application. And there used to be many magistrates in the past, one in particular comes to mind, who would always ask, well, what's your defense? And he used to be quite tough with the very junior barristers and trying to force them to give the defense. So it can be a bit intimidating, but don't feel you have to give in and say, oh, my defense is, right? You can always say, well, I have, at this moment in time, I don't have particular instructions as to that, but I understand that my client will be fighting this case and maintaining a plea of not guilty, right? You can always try and get it around that way. I heard a very wonderful phrase many years ago by a very, very senior junior, and I used it as well, and it worked quite well. She was asked, what's your defense? And she said, she stood up and said, sir, it would not be convenient for me at this moment in time to reveal that. And she sat down again. And she was so senior, the magistrate just sort of looked at her and said, oh, very well, and moved on. So that's a phrase you can use. It doesn't happen so much now in modern practice that the magistrates ask you what the defense is. So But just be aware that you don't have to reveal your defense if you are asked, and there's a couple of phrases you can use. Right, at this preliminary stage, I don't have enough instructions yet, but I understand he will be fighting this case, or I'm afraid it would not be convenient for me at this moment in time to reveal that information. And so those two helpful phrases.
Yeah, and if you really feel the need to do it for whatever reason, although of course it's usually not necessary to do so, safer to go broadly rather than precise,
yes,
defined defense. Like Kevin said, he's intending to plead not guilty, for example, or if it's a rape case, maybe it's consensual, right? Do not go detailed and narrow with it, because you don't want to limit what your client can argue going forward.
So that's very important. All right, so there are other things we then go on to. Let's say we've dealt with the objections. You want to deal with your client's backgrounds. Now, hopefully your client has got good background. They won't always have good background. They may have numerous criminal convictions, which affect how you play your hand. But if your client, and the operative phrase is relevant personal circumstances. So not everything is relevant. So what in his background is going to help him here get bail? So could it be his young age? Could it be his old age? Could it be that he's a married man with family and he's got a stable job, making a lot of money, and he's got to support that family? He's got a property he owns where he's got to pay the mortgage for, so he's not going anywhere. So these matters are all relevant matters. The most important thing is whether he's clear record or not. Does he have any previous convictions? If he's of clear record, then of course he's a man of what we call previous good character, right? So clear record is in your client's favor because it's the first time he's been in trouble before and before the courts. So you've got to consider all of this. So when you go through your client's background, you have to think always what's helpful, what's useful, what do I need? Not what do I want, what do I need to put forward before the court to get him bail, all right? And of course, the bail conditions, you don't have to suggest every bail condition that exists in every case, all right? Why is that?
Well, because of course they won't be appropriate for the particular case you're dealing with. And it will look ridiculous in the end because you're offering everything on the face of the earth. And do you want your client to actually be subject to these stringent conditions? For example, a curfew, and it's a simple shoplifting case of someone that's 50 years old, right? Certain things won't make sense, of course. So you have to think logically on those conditions.
And I think what Holden has mentioned is very important, is you don't want to unnecessarily overburden your own client by suggesting every condition under the sun. Now, of course, I know what you're all thinking. You're all thinking, well, what do I know? How do I know what is relevant? Well, my usual answer was always, well, you can get it with experience, but that answer is, of course, useless to you. I think the best thing you can always do when you're first starting is look at the facts of your case. Think about what the likely objections are, and then meet those objections with the bail conditions that you think are appropriate, and those will give you the answers. I think is the best way to deal with it when you're first starting. And then, as I said, if you do criminal practice and you go on and get more experience, then it becomes more obvious what is appropriate. And of course, your client's instructions, what they are willing to offer, what they are not willing to offer, is going to be something you also have to bear in mind, because you must always follow your client's instructions. You can't make them up for him. He tells you what he wants, and you advise him whether they are valid or not. And if he insists, you proceed on his instructions. So always bear that in mind. All right. Concessions. Remember, it's not one-way traffic. Remember, I've always said you're not going to get a perfect brief. You will have to concede things, and you will hear quite often a prosecution objection. Oh, this is a serious offence. Most criminal offences are serious, all right, in nature. So if it's an armed robbery, for instance, or a robbery of sorts, it is a serious offence. But robberies obviously differ in the mode that they are carried out, when they're carried out, how they're carried out. So they're on a sliding scale almost. So you can always, sometimes you have to concede, yes, this is a serious offence. However, you might be able to say, but it is not the most serious sort of robbery that has come before these courts before, or words to that effect. So make necessary concessions, but try to temper them where possible is always important. Now, are judges, magistrates going to ask questions, Holden?
Of course.
Right. How do we deal with them?
You have to be prepared to deal with them. And, you should know the facts of your case. You should know your client's position. And of course, the bail checklist, which of course we mentioned, will help you to have a note of those important factors that are likely to arise through any questions from the bench. If you need a moment, however, you of course can ask for some time. There's various ways of doing so, and we give some examples here. May I take instructions on this point? May I have a moment? May I have a moment to clarify the matter? The important thing is you don't want to be shuffling through your documents, looking like a mess, or having to run to your client in the back of the courtroom, trying to get quick instructions and then running back to your seat in the front. So you want to make sure that you are well prepared to deal with anything. But of course, there are going to be things that arise sometimes that no matter how much you thought you were prepared and how well prepared you were, that just come up at the hearing. And as we say, if you need time to do those things, there's plenty of ways to ask to do so in a polite, proper manner. And those are examples that you have there in the documents. One thing we say here is, if necessary, ask for the matter to be stood down and allow for additional time to take instructions. Standing down a case is explained later on, but briefly, that just means putting the case aside for a temporary moment. And if you can get instructions in 1 second, of course, and your instructing solicitor runs over to you with an answer from the client, you can carry on. But there's usually often cases where if you're really not sure on the answer, you may want to stand down for 10 minutes, for example, 15 minutes. Let the court carry on with its other business. It'll be much nicer of a situation than everyone in the courtroom being silent, looking at you, panicking, trying to figure out the answer to the court. So you can always get that extra time if you need, and everyone will understand. Just ask in a proper way. Don't say, I need a bit, and then run away and run to your client in the back of the courtroom. Say, may I take instructions on this point? May I stand down for 10 minutes? Or may we stand down until after the morning break, for example, if you think you need a bit more time to clarify certain issues with your client.
The important thing, of course, is if you do need time, don't be afraid to ask for it.
Yes.
You will be given the opportunity because, as has been already said, the court doesn't just have your one case, especially in court one. It has other matters to get on with. So you will be permitted time. So don't be afraid to ask for it in practice. And when you come back, we'll cover this later as well, and you will have seen it hopefully in some of the bail quizzes. When you come back, having been given time, always thank the court for the time given to you before you continue. And there are numerous phrases you can use. You can say, I'm grateful for the indulgence, because it is an indulgence that they've indulged you to give you that break. I'm grateful for the time given to me to take instructions. That's another phrase. Or I'm grateful for the time. So always thank the court where you have been given time to take further instructions. Now, why do we get questions that no matter how well you prepared for, you don't see it coming? Because judges are not always the most logical of people. They will ask questions which you will never have thought of, and you don't understand the logic behind. It just happens. Judges think differently. And you'll think, where did that question come from? Why on earth is he asking this question? What has this got to do with the case? And you can't say, well, I'm not answering that question. That's silly. It's got nothing to do with this case. You can't say that to a judge. As has been said, all you can do is say, may I have some time to take instruction on that matter? And then deal with the matter that way. All right. Now, of course, when we go into court, we've got to address them correctly. This is very, very important. Now, remember, we are in the criminal courts. Your bail application will be in the criminal courts. This is not a civil setting. So you do not go in and call them master, right? And certainly not if they're a female mistress, right? Master is master, male or female. Here, very simply, in the magistracy, modern terminology is sir or madam. You will sometimes hear perhaps more experienced counsel using the phrase, your worship. Okay, this is a very archaic term. It is still used from time to time. I don't use it very much. In fact, actually, I don't use it at all. And I would advise just sir, madam, if you're doing it in English. Remember, if you do prefer the phrase your worship, nothing wrong with that. It's your worship, not your warship. Many years ago, there was an experienced solicitor. I don't think he'd ever been to court for at least 300 years. And he was doing his application in English, and he kept referring to the magistrate as your warship, your warship. And the magistrate was a very experienced magistrate, and he just got tired of it. And he just said, am I a battle cruiser or a destroyer? And the solicitor looked at him and said, huh? He said, well, you've been calling me a warship for the past 2 minutes. So I'd just like to identify what type of warship I am. Or do you mean your worship? So that was rather embarrassing. So if you're going to use that phrase, ensure you pronounce it correctly. Once we get up to the district court, Your Honor, right? Your Honor all across the board. And then if you go to the High Court and you do bail pending an appeal or a High Court bail application, my lord, my lady, your lordship, not my lordship, your lordship, your ladyship, right? Try not to demote High Court judges or district court judges, and try not to promote the magistrates, right? Some don't mind the promotion in terms, so if you call them Your Honor, someone will say to you or remind you, Mr. So-and-so, we are in the magistracy, we are not in the district court or the High Court. So it's always very important to get your terminology correct. In Chinese, in all three levels, we just use one phrase. In Chinese, we use fa kun gok ha, right? Not fa kun dai ha, right? Not judge building, right? You may laugh when you watch this video, but I've heard it said before. Right, so make sure you get the terminology right in both languages. Yeah.
Also, just be careful with when you use your and my. I've seen people go in and say my honor, for example. It's always your honor, my worship. Be careful with that. So it's a handy guide here. One tool I found useful when I first started practice was just writing in big words on my bullet points for that day. My lord, just to remember. I don't call this judge anything else than that. It's just easy to keep it in your mind, because when you first start off and you're jumping between different courts, of course, it's easy to mess that up. So you want to make sure that you don't. It's quite embarrassing and shows that you're very junior if you do so.
I mean, it does happen. I mean, even to the experienced practitioners, as Holden says, when you've been in the magistracy today and in the district court tomorrow and you're in the high court the day after, you can get confused. It happens, unfortunately. I mean, you don't do it deliberately, of course, but try to remember the jurisdiction you're in, and hopefully you can avoid that problem. All right. So useful expressions, we're not going to go through them all. You can read these yourself. All right. They're very straightforward, and you can see there that we give you lots of examples of how you can ask for further time, how you call the prosecutor, Madam Prosecutor, Mr. Prosecutor, the prosecutor, the prosecution. Right. Quite often now they just say the prosecution object on this basis. Right. If we move for them, and then as you can see, this is all a glossary. Now, when you are getting towards the end of your submission, so unless I can further assist you is quite a traditional way of ending your application, because you're saying to them, that's everything I put forward. So you say, unless I can assist you further, that's the application for the defendant, and you sit down. Right? These are, I mean, again, these are all stylistic. You can pick whatever one you feel is suitable to your style. All right, no one or particular one is right or wrong. It's just a matter of style.
Yeah, if they just granted bail to your client, don't walk out saying thanks, sir. You don't do that. Don't beg. Don't be informal and just say thanks. They're not doing you any favor here. It's a proper system of justice we have going on.
Just finish it very, very, very
properly and
formally. I mean, even whether you're granted bail or not, if you're a private brief, just say, I'm grateful, sir, or I'm obliged, madam, may I be excused? And then leave the courtroom. Right? There's always a polite way of leaving the courtroom. So always maintain etiquette right through to the end, even if you don't get bail. And you will know when you are not going to get bail, when you're going to get bail. You'll know. So don't worry about it. Now, bail extended on the same terms. You see this phrase best. You will see this written very often on duty lawyer papers. In fact, we write it ourselves, BEST, bail extended on the same terms. It means that his bail will continue on the same conditions as last time. RIJC, you will sometimes see remanded in jail custody. So they are sent off to the CSD prisons while they await the next court hearing. You will also sometimes see RIPC, remanded in police custody, where they're sent back to the police station. Generally, defendants prefer to go to prison under CSD, so JC, because they've got all the facilities there. Police station prisons are not very nice at all. They are really overcrowded, small, and not exactly sanitary. So that's why you have to be aware whether it's RIJC, remanded in jail custody, CSD, or RIPC, right, remanded in police custody. All right. OC case is the officer in charge of the case, so that's for the prosecution. Backsheet, very important. Backsheet, you need that. Your backsheet as a barrister. The solicitor must issue the backsheet to counsel, which confirms the details, in particular his fees and the court he's going to, and very briefly what time he's going to go there, and the name of the client, and the purpose of his retainment. Right? Actually, BU is to bring up. So what that means is sometimes you may have a defendant who's got multiple cases. So he's remanded in jail custody, but he's got to come up again for another case. So he has to be brought up, right? If he has a case which is 6 weeks away, but he's decided all of a sudden that he wants to plead guilty earlier, then you will hear the phrase early BU, right? Early brought up, or early bring up as it should be. I.e. he's brought to court earlier than the allotted time, so his matter can be dealt with, right? So that's the meaning of BU. Stood down, adjourned, they are the same thing, or stand down, depends on the judge.
Yeah, sometimes generally adjournments will be another day, whereas opposed to standing down, as I said, might be about, you could ask for 10 minutes after the morning break, for example, where an adjournment maybe you're asking for 2 weeks, 4 weeks, 6 weeks, 8 weeks, etc., depending on the needs of the situation.
Right. Yes. So as you can see, and then if it's an adjournment, if it is a long adjournment, they will usually tell you how many days or how many weeks or how many months they wish for the matter to be adjourned. Right. Now, of course, remember, in modern practice now, when you apply for bail, it doesn't necessarily mean that your client must plead guilty or not guilty immediately on the first appearance. Sometimes plea, in fact, 99% of the time, plea will not be taken on the first appearance, right? Remember that. Sometimes your client hasn't made up their mind yet. They want to plead guilty, but they want to see what the evidence is against them, right? But they're adamant they're going to plead not guilty, but they still like to see the evidence against them. And then in that case, you can ask for no plea to be taken and then have it adjourned for X amount of weeks so that you can get the relevant documents from the prosecution, have your conference with your client, and then advise him, oh, the evidence is relatively strong against you, or you have a runnable case, you can plead not guilty or guilty depending on the circumstances. All right, so bear that in mind. That's modern practice, right? Don't think, oh, bail must be not guilty. No.
And also, just on that note, oftentimes the prosecution will also not be ready for your client to enter a plea yet. They might be conducting further inquiries. Legal advice might be being sought. So you would still want to, of course, make a bail application if that's your instructions, even if prosecution are seeking an adjournment of the matter. And I just want to highlight one thing, just so there's no confusion. If it's a simple matter that you need to clarify your client's instructions related to bail, you usually will not be seeking an adjournment, because that means they will be remanded in custody pending the next hearing. So the only thing you would really be able to do then is to quickly get those instructions if you don't have them yet, or stand the matter down during the same day to be heard and brought back to the court, whether it's 10 minutes later after the morning break. But you do not want to seek an adjournment of the case if it's just a simple matter that you want to clarify with your client for bail. And just on that whole topic, there may be situations where you just need a moment. You don't actually need to stand down, but you just need a moment just to find the note in your file that you made in relation to the issue that's come up. So again, there's other ways to do that. Just ask for a moment of time and do it quickly on the spot, rather than getting into it, standing down or an adjournment. Yeah.
All right, so that covers everything for this lecture. What I do want you to go away is, of course, in your own notes, is just make a note of 2 or 3 things which you felt were useful for you in today's lecture, and we will be back with 2.5 shortly. So in 2.5, we will go through the bail checklist, we will go through the skills guide for bail, and of course, we'll deal with the quizzes. All right, thank you very much.
Thank you.
Okay.